Ladies and gentlemen, welcome to our program, The People's Justice, Clarence Thomas and the Constitutional Stories That Define Him. Please welcome John Malcolm, Vice President of the Heritage Foundation's Institute for Constitutional Government and Director of the Meese Center for Legal and Judicial Studies.
Well, welcome, everybody. On behalf of the Heritage Foundation and our co-host for this event, the Federalist Society, we are very pleased that you are here today. We are here to discuss a fabulous new book that was just released yesterday, titled, and here it is, The People's Justice, Clarence Thomas and the Constitutional Stories That Define Him, which focuses on 12 cases that serve to illuminate Justice Thomas's approach to the law, his impact on the law, and the impact that these cases had on ordinary citizens. We are joined today by the author of that book, Judge Amul Thapar. Judge Thapar is a judge on the United States Court of Appeals for the Sixth Circuit, where he has served since 2017 after being nominated by President Trump. Prior to that, Judge Thapar had served as a federal prosecutor, including serving as the United States Attorney for the Eastern District of Kentucky and as a U.S. District Court judge for that district, having been nominated to that position by President George W. Bush. After Judge Thapar speaks, we will hear from three very distinguished lawyers in their own right who argued three of the cases that are featured in the book, and they will describe how they got involved in these cases and how they approached their Supreme Court arguments. Randy Barnett, who argued Gonzalez versus Raich, is the Patrick Hotung Professor of Constitutional Law at Georgetown Law School. Professor Barnett is the author of 12 books himself and well over 100 scholarly articles. Scott Bullock, who argued Kelo versus City of New London, is the president and chief counsel at the Institute for Justice, where he has been since it was founded in 1991. The Institute for Justice is a nonprofit public interest firm that fights to end abuses of government power and secure the constitutional rights of the people. Like Professor Barnett, Scott has also published dozens of articles and is a frequent media presence, sharing his views on constitutional litigation. Then we will hear from Alan Gura. Alan is the vice president for litigation at the Institute for Free Speech, which he joined in 2021. The Institute for Free Speech promotes and defends First Amendment rights. Prior to joining the Institute for Free Speech, he was in private practice, where he argued a number of important constitutional cases, including McDonald versus City of Chicago, which is featured in the book, and its predecessor case, District of Columbia versus Heller. Judge Thapar, the floor is yours.
Thank you. Is it okay if I use the?
Totally up to you.
I'll switch up on you. Is it going to screw up with the microphones? Okay, great. Well, thank you very much for having me. It's really a treat and an honor to be here with all of you. I'm going to talk just very briefly about why I wrote the book. I think one of the many things we lost when we lost Justice Scalia is our evangelist for originalism. Justice Scalia served such an important role in talking often about originalism. He often said that when he started talking about originalism, everyone would think he was a bear and run from the room. Now, to me, it's the only philosophy people talk about. Either the people who tout it, like myself, as the proper methodology to interpret the Constitution, or the critics who don't bring something else to the party, but would rather critique originalism. And with Justice Scalia's passing, the leading originalist on the court is now Clarence Thomas. Few can debate that, and very few attack his methodology these days, because they know they can't win. And the book proves it. The fascinating thing for me in working on the book, I started with a book about originalism for ordinary people. That's what I wanted, meaning not only lawyers, but everyone else. Because I thought the next step for us, as Justice Scalia said, we have an obligation to fly the flag. And to me, the next step was taking it straight to the American people. And that was the goal of this book. And I think when you read the book, no matter who you are, you're going to be surprised. Maybe it's how often originalism is actually in favor of the little guy. Maybe that'll surprise you. Maybe it's how strong a voice Clarence Thomas has, including a black voice that no one ever talks about. And maybe what will surprise you is the courage of the litigants like Suzette Kelo, who you'll hear about today from her lawyer, Scott Bullock. Litigants like Angel Raish, who again, you'll hear about today from her lawyer, Randy Barnett. And litigants like Otis McDonald, who once again you'll hear about from his lawyer, Alan Gura. These litigants and these lawyers are truly what make America great, because without them, these cases would not be there. And these litigants who just wanted a chance to fight what they viewed was wrong would not have an opportunity to do so. Because without great lawyers like these gentlemen, there is no Constitution. So each of them will give you today the inside scoop. And I couldn't have written this book without them. Extensive interviews, they reviewed my work. They were critical in each of the respective chapters. So I thank each of them. I thank you for coming today, and I look forward to a discussion about the book and the chapters therein.
Well, first of all, thanks, John, for having me, and thanks, Amul, for writing this book. This is a phenomenal book. You all need to read it. You'll really enjoy it. I certainly enjoyed the chapter on the Raich case, and I can attest to its accuracy, which I assume is true of all the other chapters as well. So it's not always true of journalistic reports of the cases that we've worked on. I've been asked to talk about how I became involved in the Raich litigation. And I'm going to do that, then I'm going to close by sort of drawing a lesson that I learned from the Raich litigation that I think is important today. I got involved because there was, once upon a time, I was considered the nation's leading authority on the Ninth Amendment, which all of you know because it's so important. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And I see Chuck Cooper in the audience here. Back when neither of us had gray hair, we were on the Federalist Society circuit debating the Ninth Amendment over and over again in front of chapters. And what happened was there was a lawsuit in California involving the Oakland Cannabis Buyers Cooperative, which I will just call OCBC. And the federal government wanted to put OCBC out of business. That's discussed in the book here in this chapter. But the trial judge in that case was Charles Breyer, who was Justice Breyer's brother. And Charles Breyer, Judge Breyer, asked the parties to brief the Ninth Amendment. He thought the Ninth Amendment might have something to do with the case. And so Robert Raich, who ultimately married Angel Raich, making Angel Raich, was going around the country trying to find somebody who knew about the Ninth Amendment. And he comes to me when I was at Boston University. I remember getting the phone call from him. I was in my office. And he was telling me about this case, and he asked me if I'd be willing to get involved. Well, unusually, it actually was a Ninth Amendment case. It was a federal case. It was not a state case. So it was not a 14th Amendment case. And I was, supportive of the policies that were being advanced by the lawsuit. So I said, sure, I would. And I helped them write the Ninth Amendment part of the brief that they wrote to the trial judge, who immediately or subsequently lost all interest in the Ninth Amendment, as judges always do. But by this time, I was involved in the case, which was primarily a Commerce Clause challenge with a Due Process Clause fundamental rights challenge as well. And the problem with the case was that the facts involved people going into the Oakland Cannabis Buyers Cooperative with money in their pocket and no marijuana, coming out of the Cannabis Buyers Cooperative with less money in their pocket and marijuana, which means that money and marijuana are changing hands in that building. And I don't know about you, but I know, according to my reading of the original meaning of the word commerce, that's commerce. So commerce was happening in that building, according to the original meaning of commerce. Now, it was intrastate, wholly intrastate, which still meant that there was some basis for a constitutional objection. But I said that, and we took that case all the way to the Supreme Court. We actually got to the Supreme Court in that case on a theory of medical necessity, which I needn't bore you with, but it was not a constitutional challenge. It was a statutory basis. But the point is I thought we needed a case with better facts. We needed a case where there was no money and no marijuana changing hands. So as the book relates, Rob Raich, who by this time, I was co-counsel with him in that case, came to me and said, what do you think about bringing our own lawsuit involving facts that were more favorable to a Commerce Clause challenge? And he said he knew of two people who would be good plaintiffs in the case. One was Angel Raich, who he had recently married, and the other was Diane Monson, who both of whom are discussed in the book. And it was a result of that the three of us, Diane Monson's lawyer, Rob Raich, and myself, brought the lawsuit in the Northern District of California to enjoin the application of the Controlled Substances Act to our clients. And that was the beginning of my new career as a constitutional lawyer. Formerly, my legal experience was limited to trying murder trials to juries in Chicago. So this was a pretty big departure from that, although I'm very pleased to have done both. Both tried jury trials, murder cases to jury trials in Chicago, and argued in the U.S. Supreme Court. So now, in the short time I have left, let me draw a lesson from the case that I learned, that is not in the book, although the whole book stands for this proposition. Many of you have heard of legal realism, and legal realism can be sort of digested as based on what the judge's political preferences are. That what the judges will do is they'll decide how they want a case to come out, and then they'll marshal whatever legal resources are necessary to justify that outcome, but the outcome is being determined by their priors. So it's all very outcome-based. I, by the way, am not a very big adherent to the legal realism view. I don't think it's an accurate description about how lower court judges decide cases. I think it can be a somewhat accurate description about how Supreme Court justices sometimes decide cases, but with a twist, with a modification, which this case represents. Because when we went into this case, you would think, I'm coming out of the Ninth Circuit with a medical marijuana case representing two people who are sick and need medical marijuana to survive. I win in the Ninth Circuit in the Court of Appeals with the two liberal judges. The one Reagan appointee, I don't get the vote of the Reagan appointee. I get two liberal judges. You would think going to the Supreme Court, I would have had a shot at the progressive justices on the court. And that would have been Justice Ginsburg, Justice Stevens, Justice Souter, Justice Kennedy. You would have thought I had a shot at them. But I never had a shot at them. I knew I didn't have a shot at them. I mean, it's when you're arguing a case in the Supreme Court, you tell yourself stories about how you might get this judge or you might get that judge, that vote. But I knew better. I knew I was never going to stand a chance with them. Why not? If the legal realism story is true, even as I think it sort of is, why not? And that is, I think, because I think what justices do, they don't decide cases based on doctrine, unless, necessarily. I don't think they consider themselves all that bound by their own doctrine. So in that sense, I think realism is right. But I do think they decide cases based on their deep-seated constitutional principles. And what separates the left side of the court from the right side of the court is a disagreement about what those principles should be. And that's the reason why I never had a shot at the left side of the court, because the left side of the court put their principled commitment to virtually unlimited federal power ahead of their compassion for the sick and the dying. And at some level, you kind of have to admire that. However, we did get 3 votes. We got 3 votes from justices who put their principle to limited and enumerated powers ahead of whatever concerns they may have had about marijuana, the Ninth Circuit, or whatever. And those were Chief Justice Rehnquist, who was at that point dying of cancer, Justice O'Connor, and the subject of this book, Justice Clarence Thomas. Justice Clarence Thomas may have supported the policies in the case. In fact, he declined to join one paragraph of Justice O'Connor's dissenting opinion in which she said if she were a legislator, she would not have voted for this law. That's the only paragraph that Justice Thomas declined to concur with, to sign on to, when he joined her opinion. So maybe he did agree with the policy, but that's not what drove his decision, and it didn't drive the decisions of the Chief Justice or of O'Connor. Their decision was driven by their principled commitment to federalism, as reflected in the written Constitution. And that's how we beat the spread as the chapter ends. We got, instead of just getting one vote, we got 3 votes because there were 3 justices who were willing to do that. And that's, I think, the legal realism of that case. It's a commitment to principles over facts, and sometimes, but those principles will vary depending on which justice you talk to.
Thank you. Scott?
Well, thanks, John, and congratulations, Judge, on a really terrific book. I'm going to talk a little bit about the Kelo case, which many of you might be familiar with, and then talk a little bit, too, about Justice Thomas's stirring dissent in that case. If you recall, the Kelo case involved what we at the Institute for Justice call an abuse of eminent domain, where eminent domain is not being used for a traditional public use as envisioned by the Constitution, a road, a bridge, a public building, but is instead used for private economic development. And this had increasingly become a real problem that had been going on in many states throughout the 1980s, and it really picked up steam in the 1990s and on into the 2000s. And it was a classic case of big government teaming up with large development interests and business interests in order to take the property of basically poor and working class people throughout the country. And so we saw this as a gross violation of the Constitution and something that needed to be addressed, not only to help the people that were being victimized by this, but to also restore important constitutional principles. And so we took on a whole series of cases, starting in the 1990s on up into the 2000s and beyond, that would try to limit government's abuse of the eminent domain power. The problem that we had is that the Supreme Court, in a 1954 case called Berman versus Parker and a 1984 case called Hawaii Housing Authority versus Midkiff, had recognized a very expansive definition of eminent domain, where eminent domain was used not for public uses, but for the court interpreted to mean public purposes, and then eventually, and especially in some follow-up litigation, that meant public benefits. And all the government would have to do is to show, in some even theoretical sense, that a new development project would lead to higher taxes, more job growth, greater economic development, and that was a public benefit that justified the use of eminent domain, even though all these cases involved the taking of property from one private owner to hand it over to another private owner. That sounds like a private use, which would violate the Constitution. And so we litigated these cases with the hope that one day the Supreme Court would take up this issue and to at least put some outer limits on the use of eminent domain, because the court had never explicitly signed off on the use of eminent domain purely for economic development purposes. Higher taxes, more job growth. You could make the argument it was implied in these broad decisions from the 1950s and 1980s, but they had never explicitly held that. So we said we at least want to get a limit on the eminent domain power to exclude these pure private takings for economic development purposes. And that led us to one case that we litigated from the trial court in Connecticut up to the Connecticut Supreme Court, and then on up to the U.S. Supreme Court. And it was a classic case of eminent domain abuse. It was an old neighborhood in the Fort Trumbull section of New London, Connecticut, that had been there for over 100 years. It was a working class neighborhood that had a quite nice view of the water, the river that pours out into the Long Island Sound. And around that time, what New London thought was going to be their economic savior, the Pfizer Corporation, agreed to build its new headquarters there. And part of the agreement with Pfizer to come to this neighborhood was to redevelop the Fort Trumbull neighborhood that happened to be adjacent to the new Pfizer facility. And so the New London City Council authorized the use of eminent domain to take from Suzette Kelo and her neighbors to give to private developers to enhance, supposedly enhance the new Pfizer facility that was going in. And so we litigated this case. We partially won at the trial court. We lost by 1 vote at the Connecticut Supreme Court. The dissent in the Connecticut Supreme Court said maybe this is time for the court to look anew at limits on eminent domain power, and we were thrilled when the court took up the case. And as probably many of you know, the court, in a 5-4 vote, ruled against Suzette Kelo and kept this line of cases from Berman and Midkiff on up to Kelo of a very expansive definition of eminent domain abuse. You might know from reading about this and following this, there was enormous backlash to this decision as well. The public was outraged by this decision. I think it's fair to say it's perhaps the most universally despised Supreme Court decision, certainly in modern history. And we were able to get a lot of laws passed in states to curtail eminent domain abuse. And a number of state Supreme Courts stepped up and started to interpret their own state constitutions in a way that was more protective of property owners. I'll mention 3 things that I thought was really important about Justice Thomas's dissent in the opinion, because, as I mentioned, there were 4 dissenting justices. And though Justice O'Connor wrote the main dissent in the case that all the dissenting justices signed on to, and Justice Thomas wrote his own dissent. And he did some really interesting things that differed a bit from what Justice O'Connor's dissent did. Is, of course, he had a really robust defense of originalism that, interestingly, only got his vote on the court. He was willing to take an even more radical position than what the Institute for Justice was claiming in this case, because we knew we had to get to 5 votes. Maybe the justices would not be willing to overturn decisions like Berman and Midkiff that we thought were wrongly decided, but could at least be distinguished from what the government was trying to do in the Kelo case. Justice Thomas said Berman and Midkiff were wrongly decided, and had a really interesting and I think very persuasive historical analysis of what public use actually meant. It meant public projects or uses like utilities and railroads where people had the right to use the property even if there was some private involvement with it. So I think it was really an interesting and, as I said, persuasive defense of what the founders really meant by public use, and was willing to give that life. And the other 2 things I thought was really interesting that brings out some of the themes in the judge's book as well is that Justice Thomas started talking a little bit about what was really going on in the Kelo case. And his kind of realpolitik analysis, where he put in this first paragraph of his dissent that the takings here were suspiciously agreeable to the Pfizer Corporation. And Justice Stevens, who wrote the majority opinion, had this very civics book-like approach to what New London was doing, where they kept emphasizing the planning process that they went through, and they had hearings, and they listened to people, and then at the end of this long process where they got all the approvals from the various government agencies, the development plan happened to be exactly what Pfizer wanted in the development plan from its origin. And he said, this is the way that these things typically go down, and looked at it from that perspective, which I think was really important. Justice O'Connor also took that approach a bit in her dissenting opinion. And then what Justice Thomas did as well, that Justice O'Connor did not do, but I thought was really important, and it drew upon some of the amicus briefs that we had, was to really talk about the sordid history of eminent domain abuse, and especially urban renewal projects in the 1950s and 1960s that destroyed, frankly, many inner city neighborhoods. Berman versus Parker, which was the subject of the 1950s decision I had mentioned, happened only a couple miles away from here in southwest Washington, D.C., where they took an entire neighborhood in order to do redevelopment projects. And as Justice Thomas noted in his dissent, 90% of that neighborhood was black. And this happened in city after city. Where I grew up in Pittsburgh, the Hill District, which was a robust, thriving, largely black neighborhood, was destroyed to make way for new development projects, including the Civic Arena and others. And he was willing to call that out. And he even quoted James Baldwin's famous description of urban renewal, as, to use the phraseology of that time, Negro removal. Some of this was planned, some of this was deliberate, others it was just well-intentioned, but people not understanding how, what would the effect of urban renewal would be. And Justice Thomas called out people who would support this as, you are not only signing off on something that's a really bad idea and contrary to the original intent of the Constitution, but it's also something that has this really terrible historical pedigree. Let me leave it at that.
Thanks. Alan?
Thank you so much, John Heritage, for having us over here. And thank you so much, Judge Thapar, for writing a wonderful book, which I encourage everyone to go out and get and read. What I love about this book is it really reflects what I love about the law, at least the kind of law that we practice here, which is it's about people's personal stories and how they connect to the larger story of our country. And perhaps no case that I've ever worked on has really brought that home as much as McDonald versus Chicago, where I got to work with really a wonderful man, Otis McDonald, who felt the history. He understood his family's connection to the story that we were telling and to his individual rights today. And it was just a wonderful arc of history to bring that home into the Supreme Court, into a decision that made a difference for so many people. It was truly an honor. Justice Thomas's decision in McDonald was decisive in the sense that we need 5 votes in the Supreme Court to prevail. To get 5 out of 9 means you get to go home happier than the people who get the 4 votes. But Justice Thomas wrote by himself an opinion that really demonstrates his fidelity to originalism, his fidelity to his own understanding of what the Constitution means and to what is the correct result. And in the end, I think it's also a decision that everybody knows was correct. It's an example of Justice Thomas being able to put his name to something that is thought to be out there as one of those things that maybe we really can't say out loud, but we all know is true. So how did I get involved in this, and what role did Justice Thomas play in the outcome? Well, in 2008, I had the honor of arguing Heller, the Heller case, D.C. versus Heller, which established for the first time solidly at the Supreme Court level that the Second Amendment protects an individual right to keep and bear arms. It's not connected to malicious service or any other kind of government obligation. The problem with Heller is that while it was a fantastic result for Mr. Heller and other people in D.C. and other federal territories, it did not apply to any other American in our relationships with the police that we see most often, our local police, our city police, our state police. I suppose it's possible for the FBI to come knocking on your door, but if you're driving your car or if you have some kind of problem, you call 911, you're generally going to be speaking with an agent of the state, not an agent of the federal government. And for much of our history, the Bill of Rights did not apply to any agents of the state. Originally, when the Constitution was framed and then the Bill of Rights shortly thereafter was ratified in 1791, the thought was that you really didn't have to worry so much about your local state governments. Those governments were much closer to you than that far-off federal government in Washington. That's what you needed the Bill of Rights protections against. In the wake of the Civil War, we realized that that was not a good arrangement. The 13th Amendment ended slavery as perhaps as a technical matter, as a legal relationship between people who are enslaved and people who purport to be their owners. But it didn't really establish what the rights of these newly freed people might be, or for that matter, what the rights of other people might be vis-a-vis the state governments. And the state governments in the South, in particular, had not been respectful of people's rights prior to the war, they sure were not respectful of people's rights after the war. And the American people understood that something had to be had to be done, and the 14th Amendment was ratified to deal with this problem. The 14th Amendment opens up by telling us that everyone who is born in the United States is a citizen of the United States and of the state where they reside. And then those citizens have rights. And no state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States, right? The very first clause of Section 1 of the 14th Amendment tells us that states cannot violate the privileges or immunities of citizenship. That's what the war was fought over. Unfortunately, shortly after the war, this theory was tested in the Supreme Court, and it was found to be wanting, at least in the eyes of the court that existed in the 1870s. In a pair of cases, the Slaughterhouse cases and then U.S. versus Cruikshank, the Supreme Court basically ratified a theory that the privileges of citizenship protected by the 14th Amendment are really privileges of national citizenship, privileges that come out of the existence of you being a U.S. citizen, not necessarily those rights that you have as a person naturally, which are those rights protected by, say, the Bill of Rights. So, for example, you have the right to visit the Bureau of Engraving and Printing in D.C. You have the right to the protection of the Navy on the high seas. Maybe you have the right to a passport. But do you have the right to speak? Do you have the right to be free of searches and seizures? Is there any kind of bodily integrity that you may have vis-a-vis the state when it imprisons you? What about the right to keep and bear arms? Well, those are more natural-sounding rights, and those are not the rights that arise from the creation of the United States, and therefore you're out of luck. Over time, that was understood to be unworkable. And so the Supreme Court set about a process of case-by-case incorporating a right that's in the Bill of Rights and applying it to the states via the Due Process Clause, the theory that when the state is told not to deprive people of life, liberty, property without due process of law, there's a substantive aspect to due process, which means there are actually things that cannot be done to you. And some of those things are the things that are in the Bill of Rights, perhaps. This theory may have been something that some legal scholars and some lawyers understood at the time of the 14th Amendment's ratification, but it was not on the minds of the Americans who ratified the 14th Amendment. Instead, we had a very rich history of contemporary media, of debates in the Congress and in state legislatures that reflected the fact that, hey, it's the Privileges or Immunities Clause. It's that thing that says states may not violate the privileges and immunities of citizenship that will transmit rights and real protections against outrages against state government. So we come to McDonald, we come to Heller. Everyone knew that the next case after Heller would be against Chicago because Chicago had an identical handgun prohibition to Washington, D.C., and that's going to be where the incorporation battle is going to be fought. But we had to decide how we're going to argue this thing. And perhaps the easy thing to have done, or at least the easier thing to have done, would have been to try to argue the case, try to frame the case only under the Due Process Clause and say, well, you know, the way that the Supreme Court has incorporated over time the Takings Clause, the First Amendment, the Fourth Amendment, and so on, well, let's just apply that process to the Second Amendment, and we'll have arguments about whether or not this right is implicit in the concept of ordered liberty, whether it's really something that's, you know, it's important enough that it has these right qualifications so that it qualifies like those other rights that have already been applied through the Due Process Clause as an aspect of substantive due process. The problem with that is that many of the people who are most enthusiastic, perhaps about gun rights in the Second Amendment, Justice Scalia, for example, were also famously on record of not believing in substantive due process. Justice Scalia, in particular, had a history of cantankerous remarks, decrying it as argle-bargle and usurpation and all the rest of it, you know, in a sort of Scalia-esque way that he had. And would Scalia and perhaps Justice Thomas or other people be willing to hold their nose and go with due process incorporation because that's what precedent says to do, knowing in the back of their mind that it's actually the right historical and originalist outcome because the history and the originalism supports application of the Second Amendment through the Privileges and Immunities Clause. And then what would the liberals do? What would the progressives do, right? There are many people who are in the more progressive side of things in this country who don't perhaps care for gun rights all that much, but they do care about the idea that states have to follow national civil rights standards. And they want to confirm that the process of applying the Bill of Rights to the states is not just something that the Warren Court made up in the 60s, but it has real historical and textual pedigree. And might we get some of their votes? Might we get some of their support? In any event, I decided that we couldn't really gamble. We had to, of course, present both arguments. And of course, there's one other advantage that the PRI, the Privileges and Immunities argument, has over the due process argument has, which is that it's correct. Okay. This is what the Constitution provides. There's no question that the historical record supports this. So we made both arguments, knowing that we had to appeal to the broadest array of potential votes. We had to perhaps cobble 5 votes together. And I also knew that while the Privileges and Immunities argument is not one that the Supreme Court sees every day, there's really nothing I could have done to change the justices' minds about substantive due process. All the justices were familiar with the theory. They all had their ideas about it. This is not, we're not going to be teaching them anything new. They probably have some strong notions of what to do in a case like that. So the bulk of the briefing, not all of it, but a fair amount of briefing was spent on talking about the Privileges or Immunities argument and the historical originalist record that supports it, or at least supports the result if someone's not willing to go along with actually voting that way. After all, Heller had been all about originalism. Even Justice Stevens' dissent was historically grounded. It was bad history, but it was history, I suppose. And so it would be really strange to argue McDonald 2 years later, only talking about precedent and nothing at all about what the framers of the 14th Amendment actually believed and what language they used and how that language was understood by the public at the time. It's interesting. There was a companion case that had been filed by another group that focused only on the due process arguments. That case was not granted for cert. Ours was, and it's interesting if you look at the record on cert, what the city of Chicago did with these 2 petitions. The city basically conceded that the court couldn't avoid the case, but they said, just take the due process argument. Don't take the Privileges and Immunities argument. It's old stuff. It's water under the bridge. It's crazy. And yet the court took the case that presented both arguments. And when the opinions came out, we could see why. Justice Thomas did not vote with the 4 other conservative justices who applied sort of a straightforward analysis under substantive due process, but rather he supplied the 5th vote under a theory that the Privileges or Immunities Clause, the original history of the 14th Amendment, the original meaning of those words that were used by the framers as understood by the ratifying public at the time, that is what commands the result. He at least agreed that the right was fundamental, which is sort of the magic language that you need to give that to qualify under substantive due process incorporation. But he didn't otherwise join Justice Alito's opinion, which was a plurality. And so for the first time in history, for the first time ever since the ratification of the 14th Amendment in 1868, we had an opinion at the Supreme Court that was consequential, that was decisive, and it turned the outcome of a very important case on the Privileges or Immunities Clause and on the original history of the 14th Amendment and of what happened during Reconstruction. And that was just absolutely fantastic. And I hope that was the beginning of something, or at least it sort of keeps the flame lit so that in another case, in a future case, we would be able to look again at the Privileges and Immunities Clause. And Justice Thomas acknowledged that going this route requires us to answer difficult questions about what else this language might mean. But as he also notes in his opinion, at least those are questions that the Constitution requires us to confront. And I look forward to the court, perhaps at a braver time in the future, picking up where Justice Thomas has left off and continuing with that exploration of the 14th Amendment. Thanks.
Thank you, Alan. So, Judge, I have a few questions for you related to the book, and then I have some other questions, gentlemen, where I promise you I will invite you into the discussion. So, Judge, you actually begin the book with a very fascinating story about Justice Thomas walking out of a church, St. Joseph's, about a half a block away from here, in 1998. I was wondering whether you could quickly sort of retell that story and say why you chose to highlight that story as at the beginning of your book.
So Justice Thomas was with a few of his clerks at daily mass, and he's walking out of St. Joseph's. And a homeless man comes running up to him and says, "Justice, Justice, I've got a petition for you." And the clerks brace. And Nicole, who recounted the story for me, Nicole Garnett, says she instinctively wanted to put herself between herself and this man. And yet the justice waved them away and went and talked to the homeless man. And he was quite animated, Nicole observed. And the justice came back. And he said, "You know, these are hard days for him. He just lost his mother." And he then, at the clerk's request, told them the story of the relationship between Justice Thomas and this homeless man. This homeless man had had falling out with his mother because he was addicted to drugs. Justice Thomas counseled him. And he counseled him to get off drugs. And he had done so. And he had reconciled with his mother. And she, after 2 years, I think it was about 2 years had passed, 2 years after they reconciled. And that was what it was all about. So why do I tell that story? Because so few people, when I researched this book and talked to these gentlemen and talked to others, what I discovered is how much Justice Thomas cares about the real people in each case. That's his character. Yet you never hear it. You hear the criticisms. But no one talks about how he's the one person. In each of these cases and every other case, he had a note towards the end of his opinion in Raich about the empathy, even though, as Randy pointed out, he didn't join the paragraph saying, "I would have voted for this." Right? Everyone knows Justice Thomas believes in law and order. He might not think that that's the best policy. But A, his oath was more important than what he thought, and B, cared at the end, after he got through all the constitutional points and all the points that bound him, because he will rule, if the Constitution compels it, Justice Thomas is going to do it. And I say that in the introduction. But at the end of the day, he also had a note for them, in his opinion, about the empathy he felt. Why? Because Justice Thomas cares about people, and no one ever talks about it.
Well, so in fact, you make the claim in your book that Justice Thomas's commitment to originalism and his love of ordinary people are connected. That's why you have the title of your book, The People's Justice. Can you talk a little bit about that?
Yeah, so what is originalism at its core? It reflects the will of the American people. The American people gave up certain God-given rights to a limited federal government. Limited in that they couldn't do the things they did in Raich in Justice Thomas's mind. Limited in that they couldn't do the things in Kelo in Justice Thomas's mind. And limited in that they couldn't take away your right to protect yourself. And I think it's really important that when you think about originalism and you think about the meaning of the document and you think about what the document is, and you understand it's a contract in some sense between the American people and their government. As Randy says, and I quote often, the Constitution is the document that governs those that govern us. In other words, government officials are the ones who take an oath to, quote unquote, again to quote Randy, this Constitution, meaning the words and concepts in that document as they were understood. And Justice Thomas understands that better than anyone. And what happens when you stick to the original meaning? You often protect the little guy. You don't believe me? This book proves it. So when I went through my confirmation hearing, I was told by senators that originalism protects the big guy at the expense of the little guy. This book proves the opposite. They told me that it protects the corporations at the expense of the consumers. This book proves the opposite. And it's not the book that proves it. It's the cases in Justice Thomas's words.
So some of the cases that you cover in the book are pretty famous, and some of them are somewhat more obscure. You obviously had a broad array of cases to choose from. How did you go about picking the cases you wanted to include in the book?
Yeah, as I note in the beginning, with an originalist, the one thing Justice Scalia used to say is that you're not being a good judge if you like all of your results, right? You're not adhering to your oath. And I think what Justice Thomas's critics do, and I say this front and center, look, the introduction and conclusion are my own. I lay my thoughts on the table. You know when you read the introduction and conclusion that A, I'm an originalist, and B, I think Justice Thomas is an American here. There's no debate about that. I'm not going to hide from it. That's what I think. You want to bring the guns and discuss it with me? Bring them. But in between, the stories of American people and their phenomenal lawyers trying to protect themselves, often from government. Kelo is a case that Justice Thomas said was a terrible case of government overreach. The punchline, Scott, I don't know if you told him the punchline. I went to New London, Connecticut. I took a picture of where Suzette Kelo's home once stood. It is a barren field. 8 years after Pfizer came in, they left. Who's for the corporation? I already forgot your question. I'm on my soapbox.
About how you picked and chose your cases, but this is great.
I picked the cases. I want to end the question so you can ask these gentlemen. I'm sorry, I've been on a soapbox too long. I picked these cases because I thought they reflected a cross-section of Justice Thomas's jurisprudence. And they responded to the critiques I saw out there, like the ones I brought up, like that he's a traitor to his race. I mean, in the McDonald case, can I say one more thing, and then I'm going to stop?
I've got a couple
I promise.
more questions, but you take your time.
In the McDonald case, he points out that Frederick Douglass said that the southern states after the Civil War were passing black codes. What were black codes? They were to take away black individuals' rights to bear arms. And Frederick Douglass pointed out, without the right to bear arms, we will never have equality. That is why the Privilege or Immunities Clause, as Justice Thomas so thoughtfully laid out, it was one of the reasons it was included in the 14th Amendment. And when you read Otis McDonald's story, when you read how many efforts he tried, he was a reluctant, I mean, he wanted, look, he wasn't against guns, but he tried everything to protect his family. And he's got a remarkable story. It's recounted in the book. I think you'll enjoy it when you read it. 6 different crimes his family suffered before he finally said, "It's enough." When someone was found in the garage of his house under his car, he said, "I can't call the police in time." Thanks to an eagle-eyed neighbor, that person was arrested before they came in the house and harmed the family. He had 3 kids and a wife and himself. It was too late. If he was picking up the phone and calling 911, it was too late if someone's in your house. So Otis brought this case. The grandson of slaves and a descendant of slaves penned the opinion restoring his right.
So that leads perfectly into my next question, which is that it's well known that Justice Thomas at one point described himself as a black power radical before he became a conservative. Some people think that this is evidence that he somehow sold out. On the other hand, some people think that this is there's a consistent thread that connects his views as a radical to his now conservative position. So I'm wondering whether you have any thoughts about that.
I absolutely think it's consistent in the way he has in his own mind developed. And I think this may surprise people in this book. He is a student of Frederick Douglass. You can't deny it because you'll see his words repeatedly in this book, quoted by Justice Thomas in multiple chapters, in multiple cases. He seems to me to be a student of Thomas Sowell. And although I haven't seen him quote him, although I have not done this search and maybe someday I will, he seems to have a little Malcolm X in him. And in fact, one of his clerks wrote an article called Clarence X. And so I think there's no denying it. I've never asked him, I don't think he would deny it. He admires Frederick Douglass. He admires Thomas Sowell. And the voice is powerful. Look, he's an originalist first. There is no one that takes originalism more seriously than Clarence Thomas. But he is the opposite of a traitor to his race. He's a champion for his race. He talks about, in the Grutter chapter, the soft bigotry of low expectations. He firmly believes that, and think about this, Grutter involves education. The second chapter involves education. They're both titled after words he used quoting Frederick Douglass. He firmly believes that what happened to him in his life is available to everyone. Remember, if you haven't read My Grandfather's Son, I highly recommend it because he talks about how poor he was growing up. His mom made $10 a week. She had to give up, him and his brother, to her father and their grandfather. And their grandfather taught him multiple important lessons, as the book recounts, but two that I recount in the book. Three. Education means emancipation. It's why his grandfather saved up money and sent them to Catholic schools. Something you see tied into Chapter 2 about vouchers. Chapter 3, Do Nothing With Us is the title, quoting Frederick Douglass, who Justice Thomas quotes there. And what he talked about there is, if you hold the bar high for any race, that race will achieve it if they put their mind to it. And if you cheat us by lowering the bar for one race while keeping the bar high for another, you are harming us long term. It's a powerful voice that can't be denied. I challenge everyone here, one more thing, and I hope you'll send it to me if you find it. Go look at the Kelo case. Go look at all the accounts of the Kelo case. Find me what Scott pointed out. Find me the article saying one justice took up the NAACP's invitation to return to the original meaning. One justice, Clarence Thomas. You won't find it anywhere.
So, gentlemen, I want to bring you into this discussion, and this is a perfect segue, which is several of the cases, obviously, in the book touch on questions of race. And I wonder whether any of you have any thoughts about, Justice Thomas's unique views on racial issues and how he thinks that the law should address racial issues. Anybody want to jump in?
Well, I just think the judge just sort of summarized the answer to that question as best anybody could, better than I could.
Okay. What about views on the Equal Protection Clause more broadly?
Well, I think that...
Or the 14th Amendment in general, but fine.
Yeah, I would say a little bit about the 14th Amendment because it's something that Alan touched on in his remarks, where Justice Thomas has very interesting views on this. He is willing to do something that IJ has long advocated, which is resurrect the Privileges or Immunities Clause. And Alan took that approach, which we were very happy about when he argued McDonald, and was, interestingly enough, attacked by Justice Scalia, too, who I think called you a darling of the professoriate class for bringing in privileges or immunities in a typical
I want to know all the professors advocating this, because I'm going to have to find them.
That's right.
I haven't seen it.
Right. So he's willing to go and say, listen, even though the privileges or immunities clause, like the Ninth Amendment, raises some difficult questions that we're going to have to grapple with as to what are those rights and how they're going to be recognized by the court. But we have to do that if we're going to stay true to the original intent of the Constitution. The other thing, too, about the 14th Amendment that I think is also an interesting contrast between Justice Thomas and Justice Scalia is Justice Thomas's strong advocacy of parental rights in the Constitution as well. And it was an interesting case from 2000 called Troxel v. Granville, where Justice Scalia, who essentially really didn't believe in unenumerated rights, and he wrote a dissent in that case, basically discounting and disregarding the Supreme Court's landmark decisions in Meyer versus Nebraska and Pierce versus Society of Sisters, recognizing the rights of parents, the rights of families. Justice Scalia's approach, of course, is, well, the Constitution doesn't say anything about parents or families. And so why are we making up, in his words, those rights? Justice Thomas accepts that and thinks it is very important to recognize these unenumerated rights under the 14th Amendment, whether it's under the Privileges or Immunities Clause or the Ninth Amendment or some other type of approach. He thinks that is as robust of a part of the Constitution as the enumerated rights in the Bill of Rights.
And can I say one thing on that? Which is the chapter in the book about Brown v. Entertainment Merchants gets at that, parental rights. Justice Thomas writes a dissent about parental rights. It's about violent video games. And Justice Scalia writes the majority opinion. And that parental rights decision is fascinating and worth reading after you read the chapter, of course.
Sure, Randy. The punchline here is that for all the conservatives in the room who are skeptical about the judicial protection of unenumerated rights, I ask you, where in the Constitution does it explicitly say that parents have a right to raise their own children? If you're going to limit constitutional protections only to the rights that are specifically enumerated, you're going to have to say there is no such fundamental right. And that's the exact matter over which Justice Scalia and Justice Thomas disagreed in the Troxel case. Justice Scalia stuck with his view that this was a right that was recognized by the Declaration of Independence. It was even a right that was acknowledged by the Ninth Amendment, but he as a judge had no role whatsoever in protecting that right. That was Justice Scalia's position. Justice Thomas's position was not only was there such a right, but it should be protected with strict scrutiny the way all other constitutional rights are.
And if I would just add one more thing, I think Justice Thomas, we live in a time that's very polarized. People assign themselves to various political tribes. I think Justice Thomas's decision in McDonald highlighted also the fact that he's not afraid to depart from maybe the social conservative crowd. I'm sure that he may have heard some criticism. I sure heard criticism from my social conservative friends that if we open up the unenumerated rights Pandora's box, what are we going to find? This will be used to create all kinds of rights that don't actually exist. And we all know the litany of rights that are controversial in this respect, perhaps abortion, same-sex marriage, all these things. And Justice Thomas obviously didn't care about that. He was quite forthright in stating there are unenumerated rights. This language is expansive. Privileges or immunities is a term that encompasses more than just what's literally set out in the Bill of Rights. And we're going to answer those questions as they come and be true to our history and be true to the text. Really, I think it's a wonderful thing that he was able to do that. A true partisan would not have done that.
So I'm going to ask one more question, then I'm going to open it up to audience questions. The only thing I would ask is that you keep it very short and actually ask a question rather than giving a speech. My last question is, it's a general one. What do you all see, now that Justice Thomas has been on the court for more than 30 years, what do you see as his legacy and his long-term impact on the court and on the law?
Originalism. He really perhaps more so than Justice Scalia, really drives home the point that you must look to the original public meaning of the text, try to understand what the people actually believed that they were doing at the time. There's a modesty inherent in originalism. It's a modesty that some judges perhaps don't share, that you are not empowered to substitute your own opinion and your own policy preferences for those of the people who enacted the law, who ratified the Constitution. And that level of modesty, and it's a modesty that also empowers the people, because it really leaves to us the role of continuing to ratify, if we wish, additional constitutional texts, and to keep that Constitution something that we control, and not something that we sort of find out by accident in particular cases has been changed for us.
So I'm going to jump in and steal Scott's point, which is judicial engagement, which is something the Institute for Justice has been big on. It follows from Alan's description of Justice Thomas's contribution to originalism. At the beginning of the conservative legal movement, there were basically two tenets of the conservative legal movement: judicial restraint, the proper role of judges, and the original meaning of the text of the Constitution. How should the Constitution be interpreted? And in the early years, the restraint wing was really the dominant wing, and the originalism wing was really, really subordinate. That's when I got involved in the conservative legal movement. And over the years, it's starting to swing. It has started to swing. The Troxel case is a perfect example of where Justice Scalia, originalist though he was more in the restraint camp. And Justice Thomas was not. He was more in the engagement camp, which is the idea that it is the judge's responsibility to follow the text of the Constitution, whether that means upholding a law or striking down a law. And we need to be prepared to strike down a law. And he was perfectly prepared to strike down a law, or actually to hold a law unconstitutional. Judges don't literally strike down laws, but to hold an act of the legislature to be unconstitutional and not genuinely a law. He was prepared to do that when the original meaning of the text of the Constitution provided for that, above and beyond any other justice on the court up until this day, including at this day. And so he is still at the forefront of this movement, even beyond some of his younger colleagues.
Let's go ahead. Okay. Let's open it up to questions. Here we are. We have one right here. We have a microphone. Is there somebody? All right. Yeah. Mia, come around.
Ken Masugi, thank you very much. My question, in the New York gun case, Justice Thomas spoke about an inherent right of self-defense. I think his originalism would have been more powerful had he said the natural right of self-defense. But he was writing for the majority, which might have restrained him. What are your thoughts?
I'm sure, Ken, by the way, when you were working for Justice Thomas, I'm sure you had many discussions along those lines. Anyone?
I'm not sure there's a difference between natural and inherent. It's inherent, I guess, because it's natural. I'm not quite perceiving a difference between the two. They both take you to the same place, which is the idea that humans possess innately, inherently, naturally some sphere of autonomy and some sphere of action, and that includes self-defense. And the Second Amendment reflects that. It recognizes that right, and it gives us, it protects our right to the means by which we exercise self-defense. When we first were putting the Heller case together, we did consider actually making a Ninth Amendment argument or an unenumerated right argument, a self-defense argument. And at the time, there was some law evolving on that here in the D.C. Circuit. There was a panel decision that came out in a case called Abigail Alliance, which basically secured the right of terminally ill patients to secure access to experimental drugs without FDA approval, so that they wouldn't be forced to be put into trials and perhaps get a placebo if they could even get a chance at that. Unfortunately, while we were thinking about this, the D.C. Circuit en banc overturned that decision, and we decided that the Second Amendment was enough to talk about in Heller. So we didn't go that way. I don't know if in Bruin anybody presented specifically a Ninth Amendment sort of natural rights, unremitted right to self-defense separately, but the Second Amendment is there, and Justice Thomas was able to apply it.
In the historical materials, inherent and natural are used interchangeably, and we're from the founding all the way through until after the 14th Amendment was enacted. So the terms were often used as synonymous with each other.
Other questions? Yeah, back there.
Oh, hi, thank you for coming. So in the current court, there's been more talk about like history and tradition, and that is something that I think is more recent compared to older, more restrained versions of like textualism. And I don't know if Justice Thomas has ever explicitly used those terms, but do you guys see that the sort of history and tradition emphasis is sort of Thomas-esque originalism kind of taking over, becoming more popular? Do you see it as something that we can kind of trace to him? And is it sort of an articulation of a difference between originalism and textualism, or is it something else that's kind of being added in there?
I certainly used it in the Bruin case, which is the case that Ken was just talking about. Thoughts?
I have an article on this coming out in the Northwestern Law Review, and I just want to say it's really complicated because history and tradition...
Your article or the test?
Fortunately, the concept of the relationship between history and tradition and originalism is very complicated because history and tradition can play a variety of roles in legal determinations that may or may not have anything to do with the original meaning of the text. So history and tradition can provide evidence of what the original meaning of the text is, which is the appropriate use of history in order to do originalism. But history and tradition can also provide a substitute for original meaning, as it does in the substantive due process area, which was basically the method that Justice Alito used in the Dobbs case by asking whether a right to abortion was deeply rooted in the nation's tradition and history. Unless that is somehow rooted in the text of the Constitution, which Justice Alito declined to attempt to do, that is a free-floating standard that actually traces to the Glucksberg case, the assisted suicide case, that provides an alternative to originalism. And sometimes, I'll just let it go with that. It's complicated, and we need to be careful. And because it's complicated, we need to be very careful that every time we see history and tradition being used, does not make its use originalist. That is the most important takeaway. You have to be very careful.
Over here, Chuck.
Thank you, John. Chuck Cooper. First of all, thank you very much for this really wonderful tribute in your book and on this panel to Justice Thomas. But I want to key off of Alan's point about Justice Thomas's legacy being really his disciplined honesty in his fidelity to originalism and to original meaning, and his obvious rigidity, if you will, in subordinating his own views and insisting on subordinating, no matter how passionately, to his beliefs about what the meaning of the Constitution is. And I think the best, or a very good example of that, is his view that the Constitution also trumps previous decisions interpreting the Constitution. And I'm wondering, Judge Thapar and other panelists here, thoughts on his views regarding stare decisis. He is certainly not a fair weather originalist when it comes to stare decisis. And do you address that at all, Judge Thapar, in your book?
I don't, but it's pretty clear from his jurisprudence, as you mentioned, that he's not, to quote Justice Scalia, a faint-hearted originalist. There's a fun story that Justice Scalia used to tell where he'd say, you know, I love Clarence, but I'm not like Clarence. He's nuts. He would overturn anything if it's inconsistent with the original meaning of the Constitution. And that is, he is so faithful to the original meaning that I don't think there's ever, that I know of, been another justice like him. And so I think that he views the Constitution as supreme.
The relationship between stare decisis or precedent and original meaning is a very fraught one. because most judges, especially inferior court judges, believe in stare decisis. They need to, because they have to follow the dictates of the higher court, the courts that are higher than they are. So there needs to be a stare decisis doctrine for them. And that's called vertical stare decisis. With respect to horizontal stare decisis, I share the view that the original meaning of the Constitution should come first, and the decisions, the original meaning of previous court decisions should come second. But there is a problem with figuring out exactly when that has happened, and we need to have a standard as to what level of proof we require before we're prepared to say that a previous decision of the court is conflict with the original meaning of the text of the Constitution. And Justice Thomas has offered us a standard. If a previous decision is demonstrably erroneous, I think is the phrase. And if it isn't that phrase, someone can supply me with what the actual phrase is. If it's demonstrably erroneous, only under those circumstances should the court act to correct their precedent. So A, the first thing is we need to have a theory of stare decisis and how it relates to originalism. B, I think the most promising candidate for such a theory is the one that Justice Thomas is developing, and we need to pay more attention to his view and seeing how we can extend that view, and so that the other justices are more willing to set aside stare decisis when these previous decisions are demonstrably erroneous.
And there's a lot of debate about this, as Randy referenced, but the one thing that isn't debatable is vertical stare decisis. I think all originalists agree because they called us inferior courts, and that means we have a superior court, and the superior court's pretty clearly the Supreme Court.
I mean, that's because we have a Supreme Court clause. The Supreme Court clause in the Constitution doesn't just give the title of the court, it gives the function of the court, and it contrasts that court, the Supreme Court, with inferior courts that answer to it. State Supreme Court justices are in a different situation, a slightly different situation. They are not really lower courts in that sense. But nevertheless, it's the Constitution that provides the need for some notion of stare decisis that's vertical, that goes up and down.
I think some best examples of that is what Thomas did with Berman in the Midkiff decisions, which I think was much more willing to do that, even though they were even then over 50 years old, because they were completely historically unmoored from the text, the meaning of the Fifth Amendment. And if you read the Berman decision, for instance, it is written in this sweeping, grand language of, this is going to be an opportunity for cities to be beautiful as well as clean. And looking back at this, of course, it was an utter disaster, but it was this kind of post-war confidence in city planners to remake this. But again, wasn't based at all upon the text and meaning of the Fifth Amendment. So I think he felt even more confident in that way to say, well, I'm going to look at what the founders really meant by public use, and if that means rejecting 50-plus-year-old precedent, so be it.
John, I believe we have time for one more.
May I make a comment?
Yeah, quickly, because I got one more question. I want to give it to this woman right in front of you.
Here you go.
Do you want to?
No, go ahead.
Janice Volk Grenadier. I'm a founder of judicialpedia.com, which gives victims of the courts a voice. The grand jury, Justice Scalia and Justice Powell codified that it was the fourth arm of government and that we, the people, had the right to go into the grand jury to redress it for public corruption and to set our own special grand juries. We are blocked by the judges.
Do you have a question about Justice Thomas?
I do. What was Justice Thomas's view on the grand jury, and if we should, as the people, be allowed to redress public corruption?
I don't know.
Well, I've been in front. I have actually taken cases to a grand jury, so I actually know what it feels like to be in the grand jury room with the grand jury, and it's really a quite remarkable institution. Because as opposed to petit jurors who come and go, they sit usually for a month at a time, and you get to go in there and you have to make your case in front of them. And really what has happened since the founding until today is the complete elimination for all practical purposes of the grand jury as a check on government power. Most criminal prosecutions at the state level proceed by way of information, not indictment, which means essentially a judge has to find probable cause rather than the grand jury has to find probable cause. And we all know that grand juries can be very, very tightly controlled by prosecutors, thereby making them an arm of the prosecutors rather than an independent body itself. The Constitution basically requires a grand jury, but the Supreme Court, in criminal cases, but the Supreme Court has done away with that requirement. That is part of what I've called the lost Constitution that needs to be revived. The function of the grand jury needs to be revived, even though the rules that govern the grand jury could be changed in such a way as to make them more effective. We really need to take the grand jury more seriously. Fortunately, it hasn't been abolished yet. And so there really are grand juries whose powers could be revived, but that's going to require a lot of legislative reform. It's not something that the courts can do other than to get out of the way and stop misconstruing what the Constitution says about your right to be tried but pursuant to an indictment by a grand jury.
Well, my apologies to those of you who had questions that we did not get to. You will still have an opportunity to ask Judge Thapar because his book is fabulous. As I mentioned, we have copies for sale outside of here, which he will be happy to sign. And please take a moment and thank our panelists for being here. Great.